Okay, and we're live. Good morning, everybody. I'd like to introduce Zer Iyer. Most of you know her very well. She was with Angus and Terry for many years, and now you're with Hughes Gill today. Yeah. Um, and Zer has participated in these sessions countless times. In fact, I think it was working with her where we originally came up with the idea of doing the attorney hour. So this goes way back. So without any further ado, I'm going to hand it over to Zer, who's going to talk about all those questions we had a few months back about security.
Yeah, absolutely.
Sure, thank you.
Thank you, Paul, and it's so great to see all of you. It's been really, really long. I was able to spy a quick visit with you guys at the, I think one of the spring forums. You guys had a table, so it was great to see you guys then. I also wanted to introduce Ellen Schuster, who's one of the attorneys here at Hughes Gill Cincinnati. For those of you who know her, she also came over just recently from another firm, and so I wanted to try to integrate, even though I've been doing these with Collins for years and years, trying to integrate people into my firm so that everyone can get to know everyone better, and that you certainly have multiple people to contact if you have any questions. So without further ado, and because we were having tech issues at the beginning, let's just jump right in and not waste any time. So as Paul mentioned, I understand that there were a number of questions that were kind of posed when we were originally trying to schedule this for a couple months ago. And so for purposes of today, I'm just going to try to get through as many questions as possible. And if we don't have time to get through everything because it's just such a great discussion, we obviously have questions that we can pose for the next time that I do this with you guys. So jumping right in, the first couple questions I see were related to crime or security issues and surveillance issues. And so that's kind of, I think, the flavor of the initial couple questions here. So the first one that was posed was specifically, what is the association's responsibility for preventing crime and for ensuring that that the property is in fact, essentially safe? So first and foremost, we just want to make clear, and this is not something that you all don't know, this is just something to really encourage boards to know, which is that a homeowner association's goals and the function of an HOA is actually very, very limited in scope. An association is created to help maintain the association's common area. And that's really it. The primary focus, everything that the board should do is really first and foremost related to the protection of the physical property there at the development. So understanding that anything that the association does or takes action on really has to be related to the common area first and foremost, okay? So generally what I would say is that the association doesn't have any outright or express obligation to ensure that the property is safe or secure, however, you want to even define those terms. The primary focus, again, is making sure that the common area is maintained in a way that is not just appropriate for the neighborhood and for the governing documents, but obviously these are communities. We want common areas to be places where places that are, that look good and that feel good and that are safe generally, right? And so kind of the typical safety within the context of common area really comes from making sure that there's nothing on the common area that creates some sort of potential danger or concern to the people that would be using the common area, whether those be residents or guests or invitees, anyone that's on the common area. The association's goal should be to make sure that there are no obvious issues that are going to create dangerous situations or cause potential injury to someone. So within that kind of paradigm, the way to look at safety and security issues is there some aspect of the association's common area that is creating an unsafe condition? And when we're talking about potential criminal activity as opposed to an unsafe condition as in a tripping hazard, those are two separate things, right? One is making sure that no one's going to fall and get hurt. The other is making sure that if someone is in the common area, they are not subjected to some potential crime. And so my approach is typically to tell associations, if you have areas that are particularly dark, or you have areas that are covered in shrubbery or things like that, that are really kind of like hidden, or you have an overgrowth where potentially someone could, someone can either, stay there or could potentially, use that as cover to perform some sort of, bad act or criminal activity. It's not a bad idea for the association to be aware of those pockets of the common area where potentially things like this could happen, right? That's one thing. The second thing I would add is that although the association doesn't have any express authority for preventing crime, if in fact an owner has brought to your attention that street lights are out, or that it's particularly dark in part of the garage, or whatever it may be, the association then is put on notice that there are potential areas of a lack of safety, right? That potentially could arise in those areas. And once we've been put on notice of that, then in fact the association should take reasonable steps to go ahead and to alleviate that. This does not mean that the association has an obligation to prevent any crime that takes place. What our focus should be is making sure that the common area is maintained in such a way that it minimizes the likelihood of things like that occurring. We can't control people. We cannot control people coming and going from the property or trespassing on the property. So there's no way to make sure that no crime ever takes place. But if we've been put on notice that there's a somewhat dangerous condition that we can correct, then the association should certainly make its best efforts to do so. I would also add that there is a really famous case, not famous, but a very well-known case in HOA law that deals with this specific issue, and it's known as Francis T. And the Francis T. case, the facts are pretty basic. There was a woman living in it was condo association, and she had requested. She had brought to the board's attention that the area in front of her home was very dimly lit and it was very dark, and she was a little bit concerned about her safety. And it's my understanding that essentially the area outside of her home was common area, and the board said, no, we're not going to have any lights installed in that part of the common area. That would be a specific light for you. It doesn't exist anywhere else, and so we're not going to do it. The homeowner came back to the board and said, okay, even if you're not going to do it, will you allow me to install it? I'll pay for everything. Can I install the light for my own safety? And the board again rebuffed her request and said, no, we're not going to allow anyone to put anything in the common area. Well, in very close proximity to those, essentially denials of her request, she was in fact followed into her home and she was assaulted. And it was a really brutal assault. And in fact, what happened is exactly what this woman was concerned and worried would happen, right? And it was essentially a case where it was determined that, when an association is aware about, and of course in that case, the association was found responsible. She ended up being assaulted, she had injuries, she sued the association and prevailed because the judge in that case said, look, you were advised that there was a somewhat dangerous or unsafe condition on the common area. Someone made a request for you to address that issue and it was not addressed. And so failing to follow up on unsafe conditions, especially when you have been notified about them or warned about them, means that the board has breached its duty, right? It's breached its duty not just to this individual owner, but potentially to anyone else. And so that case is kind of this watershed case that helps demonstrate that boards, when we talk about maintenance of the common area, we're talking about more than just making sure that the grass is cut and that, that the shrubs are trimmed, things like that. It's also when issues are brought to the association's attention, having to deal with specific concerns about safety or crime, then the association has the obligation to go ahead and to address those to the best of its ability. In this case, in the Francis P. case, it was a minimal amount of money and time and effort that would have been expended in order to safeguard this woman, and the board refused to do so, probably on aesthetic grounds, as we know, because boards are really big about those things. So, you know, the answer is generally, although the association does not have an express responsibility to prevent crime, we should be taking a look at areas of the common area, at spaces in the common area that can be better lit, or would give less likelihood for someone to be ambushed or to be attacked, right? That doesn't mean it's an affirmative duty. I consider that as a part of really maintaining the common area in a way that is not just usable, but is also safe for everyone. So it's slightly less than saying that the association has some express responsibility, but at the same time, it's recognizing that if we're told about a condition on the property, or, you know, we are aware that that's kind of a densely shrubed area, the board does have some responsibility to look into it and take some reasonable steps to eliminate that perceived threat or concern. So does that make sense to everybody, kind of the difference between the two? Okay, great. So the second question was, what are the risks associated with the what are the risks of the association maybe doing too much regarding safety and security? Let me just double check the risks of condos HOA doing too much on safety or security. So as I mentioned before, right, the association doesn't have an obligation per se to make sure that there's absolutely no criminal activity. But if the association goes kind of to the other extreme and does a bunch of stuff to make sure that, or to try to make sure, I should say, that there's no crime, that there's no potential safety or security issues, I think one of the concerns that is legitimate is that such actions can create the expectation of safety and absolute security for people who live at the development and for people who are visiting the development. And of course, an association doesn't want people to feel unsafe while they're at the property, but if the association takes on safety and security as an issue, then oftentimes owners are going to not only feel that expectation, but when you have an expectation of privacy, what happens? You tend to let your guard down, right? And when you let your guard down, there are crimes of opportunity take place, right? And if homeowners are under the impression that the association has as its top priority to make sure that there's no criminal activity at the development, that, you know, packages are never stolen, that, you know, nothing like this can happen, cars are never broken into, if there's so much of an expectation that this is kind of a completely locked, you know, kind of locked down facility, and something like that happens, then those homeowners are going to turn around to the board and expect some sort of compensation or explanation for why this happened when this was one of the priorities of the board. So, I mean, generally, I think the issue is that you never want to go you never want to explain to the members that safety and security is an association responsibility. It is always something that needs to be on the owners. We should be reminding owners that they need to be vigilant. They need to be aware of their surroundings. They need to take reasonable steps to secure themselves and their property and their cars, right? So although, again, we don't want people feeling unsafe, we do have to make sure that when associations try to kind of address things like multiple break-ins or things like that, you know, property damage related issues, we want to be really careful that we're not assuring people's safety or the security of their belongings when they're on the property. There are certain reasonable things that the association can do and will do, and that's what we can, you know, represent to the membership. But if we go too over the top with security cameras everywhere and with gates on everything, it really is the sense of just, frankly, a false sense of security, because the association can't control everything and can't control everyone. So we just don't want to create this expectation that the association is law enforcement or can act in a law enforcement capacity. And I'm going to touch on this a little bit later as we talk about, there was a question about surveillance cameras. But really, that is the primary risk of kind of doing too much when it comes to security, is that it leads people to believe that there is, in fact, that they are, in fact, always going to be safe. There is no guarantee of safety that an association should ever be giving to the community. And as a side note, well, I guess this kind of comes up in the neighborhood watch question next, but let's try not to use the word safety and security as much as possible.
I was just going to say that. We actually are really careful about it when we do surveillance camera policies, where we don't say safety cameras or security cameras. We say surveillance. We try not to use the word safety and security in the policy. We really try to stay from those words.
Yeah, it's just, again, I know that those are the typical words that people are going to use to describe what the purpose of these things are. But you really want to be careful, because, in fact, if something like this were to happen, if worst comes to worst and there is some sort of an attack or some sort of major incident, the homeowner is going to be looking at all those documents, or their lawyer is going to be looking at all the documents, every piece of paper, every word that the association has sent to the membership regarding safety and security. So when we use those words, just understand, even though they don't seem loaded, they are loaded from a liability perspective. Any questions about that? No? Oh, Sarah, yeah.
Yeah, so what's the appropriate type of disclaimer, when you are sending out any type of messages or responding to these types of concerns where you have, fixed lights or whatever?
Well, I mean, I think that you can be honest. If in fact the association has fixed lights, then we can say that we've added lights to better illuminate the common area. I don't think we have to explain what it's for, right? If it's for safety or security, or if it's to help people avoid trip and falls, whatever it is. I just think that, well, if the association is taking efforts to actually address those issues, let's address those issues. But I think we just want to be careful in how we frame it. And so I don't think it's necessarily a disclaimer. I think it's a matter of just highlighting for the community that the board is taking certain actions, which could prevent criminal activity, and it could ensure or minimize the risk of someone tripping in an area or falling because it's dimly lit. But I think that we need to focus on those affirmative steps that the board took, as opposed to explaining and trying to tie their actions to one specific outcome. Because when we tie their actions to one outcome, and we say we've added six additional lights in the common area to help with better safety and visibility. What about in that one area where why do they only have 6? Why didn't they have 10 lights? I mean, it's something like that. Are they only concerned about safety where those 6 lights were located? This all seems ludicrous, of course, but this is the way that lawyers, frankly, look at issues like this. This is how it actually, this is how it shakes out. If in fact, again, worst comes to worst and there is some sort of an activity. So I don't think that it's a disclaimer. If anything, I was going to mention, which we can segue into the next question, which is, what do you do when residents want to create a neighborhood watch in your association? So I don't know how Ellen feels, but my take is that there are pros and cons to neighborhood watch groups. Hitting on the pros first. Look, it's always better to have more involvement and more engagement by people in your community. I think we all know the prevailing problem from the beginning of time, as far as HOAs are concerned, that people don't actually want to do anything with their HOA. They want to buy into it, but they're like, I don't know, don't get in my business. Don't ask me to do anything. I just want to live in a place that looks nice. And that lack of connection and involvement by the community, it comes up in all sorts of different ways, right? You're trying to pass special assessments, and you're trying to elect directors, blah, blah, blah. So I would never discourage an association from having a group or having some sort of outlet for people to get involved in. I think it's always going to be better. I think from a safety perspective, it's always more helpful to have more eyes looking around, and more people being vigilant about what's going on in their community. I think it also helps to create bonds and a feeling of community. We're all kind of looking out for one another. That's really what it is, ideally. I also think that having a neighborhood watch can be helpful because it can provide a really simple vehicle for the association to remind people in the community about general safety tips, right? Like if you have a neighborhood watch, you can have a little section in the newsletter that has neighborhood watch tips about, like, remember to keep your doors closed, even if you're running outside, just to grab something from your car, make sure you lock your door, right? So a lot of those kind of like off the cuff, kind of simple reminders, having a neighborhood watch committee or a group of people like that, it kind of is an easy way to get that information out there routinely without necessarily tying those tips to a recent break-in or a recent package being stolen or something like that, right? Which in that case, it looks like the association is only providing guidance after the crime takes place or after the incident occurs. If you have a neighborhood watch, it's an opportunity to kind of, those people or the association can kind of constantly be reminding people in a routine and regular way about good kind of common sense approaches to safety and security for their own purposes. So I think neighborhood watches are great for those reasons. I think neighborhood watch groups have some obvious cons though. First and foremost, I think we are all well aware of some of the most egregious examples of neighborhood watch people going completely rogue. Trayvon Martin was an example of that. And in that case, that guy wasn't actually like appointed by his board. He just believed that he was. So you want to make really, really clear that a neighborhood watch is really just it is extra eyes. It's just what it's called. You're watching the neighborhood, okay? You're not, individuals in these groups cannot get involved with actually physically confronting people or stopping crime from taking place. This is not Crime Stoppers. This is neighborhood watch, right? And so if in fact the association is considering allowing or formally, recognizing a neighborhood watch group, it has to be extremely clear in what the purpose of that watch group is and what behavior is acceptable and what behavior is not. And neighborhood watch groups that aren't given those very clear parameters in writing, okay, for my purposes as legal counsel, I want this in writing. You can run into issues where it will encourage confrontations between members of the community. If you have the wrong personalities on these neighborhood watch groups, which are sometimes the people who want to be on these neighborhood watch groups, that could create chaos in the community. It obviously, as I just mentioned, it would exponentially increase the association's liability if in fact someone from an association approved neighborhood watch group ended up physically confronting, assaulting, or worse, someone that was in the community, right? Or even if it was someone who was outside, just a visitor. So I think on the whole, I think there are too many risks associated with the corporation formally recognizing and creating a neighborhood watch. That is how I feel. I think it is wiser for the association to consistently remind people of things they can do to minimize potential criminal activity, or, as I mentioned before, really those crimes of opportunity, because that's really the more likely type of crime you're going to get in your community, right? So while there are some associations that are really, really hell-bent on having neighborhood watch groups, if you're dealing with a board that really says this is out of control, the police never come out. When they come out, it's already too late. We don't have enough, we don't have enough monitoring of our community and our streets. Make sure that you're going to work with the association's legal counsel to come up with a very clear and concise set of guidelines for that neighborhood watch group, because you just don't want to basically allow people to be in charge of safety and to act like, mall cops. That's not what the association should be doing, because the people who are going to want to be in those roles are probably the last ones who should actually be in such roles, right? So you just have to be really, really careful. If in fact the community insists on doing this, you need to make sure that you're working with legal counsel so that the association is as clear as possible on what the scope of the neighborhood watch will be. And then the last consideration I would add is that you probably also will need to check with the association's insurance broker to confirm that in fact a neighborhood watch group would be considered a committee. Under your directors and officers insurance for association policies, typically it's not just gonna cover the directors and officers, it's also going to extend to committee members. But a committee like a neighborhood watch is quite different than the social committee or the parking committee or, the landscape committee. And so as a result of that, if the association is going to create some sort of a committee, some formal recognized group for this purpose, we have to make sure that the association also has insurance that would cover it. I am guessing, I'm not an insurance expert, but I'm guessing that it may not extend to a committee of this nature, in which case that might make the decision really easy for the association, because if there is an insurance coverage and actions by those individuals will not be subject to insurance, then the association probably shouldn't be doing it at all. I don't have any other thoughts about it.
Well, I was just going to say, I agree with everything you just said. I think that neighborhood watches are kind of replete with landmines. So one of my bigger concerns is that the people who are going to want to be on these committees are people who may also want to engage in some sort of harassment or selective enforcement, potentially even on the discrimination side of things, and that really can create a whole host of other issues for the association because it's an association-based group. And the fair housing issues always come up for me when I think about these kinds of groups, because sometimes they do think that they are enforcers, not just watchers and reporters.
Yeah. So I guess the takeaway is, you just really need to make sure that you're working, that the board is getting a good, solid opinion from legal counsel before they decide to proceed in either direction. And I know that from members, it just seems like it's a really easy way. There are members that are willing to, dedicate some time or to volunteer some time. I'm happy to do a couple laps around the community every night when I come home from work. And I know that it seems like it's something informal that the association can just throw together, and it would be helpful for the community. Of course, members don't understand. First of all, members never think about worst case scenario, right? Members are always going to be focused on what's the positive outcome. They never think about what the negative outcome will be. That's our job and your job. And so, it's not only that, but I just think that, you really want to make sure the board understands the scope of the pros and the cons. And like I said, I personally believe that there are some benefits to it. And if boards ultimately want to, they can accept the risk as long as they understand the risk. But most of them will not understand that risk unless they have a lawyer explaining it to them. And so once you get that opinion, if the board decides to go in one direction or another, so be it. That's ultimately, I always say boards are the ones who drive the bus. We just give the direction. So if they want to take a different path to get to where they want to go, then that's fine. But you want protection and insulation as the community manager, as the management company, right? That this is issues with safety and security fall kind of outside the general purview of management. And for that reason, because it has legal implications, that's really why boards need to be consulting with us to make sure that they understand kind of the whole scope before they make a decision one way or another. Any questions on this particular issue? I can't see everybody, but okay, just speak up if you do. I can't find the hand thing. All right. Question number 4, which is kind of related. Question number 4 is, can your condo or HOA owners go too far with their security measures? So this is kind of related to the second question we talked about, which we mentioned, which was kind of what are the risks of the association doing too much about safety and security, right? But if, you know, keep in mind that although I think most communities and people who live in HOAs, obviously we all want to feel safe where we live, right? That's kind of a very basic thing that we want. And we have the luxury of having in most places, you know, here in this country. One of the things we have to also consider, the boards have to consider is, you know, are the security measures going a little bit too far? And is it making some members actually feel uncomfortable, right? And not comfortable where they live. And this kind of ties in a little bit to what Ellen was saying earlier, in terms of selective enforcement, right? We don't want members in our community to feel as though they are prisoners in their community, right? We also don't want people, because of the security measures, to feel like all these things are being done because they're, you know, because of the segment of the community is like this, or they don't want to feel like they're being potentially targeted for safety issues or security issues, right? And so we just have to be aware of kind of making sure that when we are communicating, you know, when the association makes changes to their, you know, things for safety and security, without using those terms, that in fact people aren't made to feel like they're being watched by the association. If there are cameras everywhere, a lot of times people are like, this is kind of over the top. Now there are ways, we're going to get into that next with the discussion of cameras, but I do think that associations can go too far with security measures. This is not, you know, an episode of like lockdown. Communities are meant to feel like people can walk around freely and safely. And there are going to be people in the community who are going to have kind of privacy concerns if there's too much surveillance of the community as well. So, I mean, I do think that the answer to this question is very much similar to the risk of the association kind of doing too much, is that you just don't want a community to feel like they're under watch and under lock and key all the time. There will be some people who like that, but not everyone will like that. And so when the board decides to kind of engage in processes like putting up gates and doing other things like that, we just need to remind them that this is not going to necessarily be welcomed by everyone. And of course, if we're applying, you know, if we're talking about surveillance issues, it applies to everyone. It has to be, you know, it has to be as disparate impact as possible. So it has to be applied evenly amongst everyone and all the members, and, you know, all everyone that's there at the community. Okay, the next question, I know we're running.
Sorry, really quick, the question in the chat about the question extending to fire safety and plans.
This question is from fire safety and plans. Can they go too far with their fire safety and plan measures? Is that what you mean, Sarah?
Yeah, well, what I meant more was the implication that the HOA is responsible for that safety by sharing evacuation plans, county plans, different resources, that kind of thing. It's coming up more and more. Like, to be, where's the line between being helpful, but also then taking on this like assumed responsibility?
Yeah, and no, I do understand that. I think that it's all in the way that this information is phrased and told to the community, right? So anytime we're sending something out regarding safety or security issues, which of course we don't use those terms with the community, but anytime we're talking about this, we need to be I think, vigilant, that first and foremost, we remind people that you are responsible for your own safety. There are, the association is providing the information below just as a supplement to whatever you deem to be appropriate to safeguard yourself, your family, and your property, right? And when we're talking about like criminal issues also, we always lead with the association is not law enforcement. You are welcome, you are encouraged, in fact, to contact law enforcement if you have any concerns regarding your personal safety or the safety of your family or your property. Those need to be reported and handled by law enforcement, not the association. So similarly, I think that kind of start leading with that information is important because it first and foremost puts the responsibility on the owner as opposed to the association. We just want to provide, the association can help provide resources where information can be shared and where owners can learn more about how to better protect themselves or to protect their property as it relates to fire safety and things like that. But I think the headline should always be, you are responsible for your safety, right? But here's some information that could help you further understand kind of what your abilities are to do that. Ellen, do you want to add something?
Yes, I just wanted to kind of jump in on that from the insurance, a little bit on the insurance standpoint, because it's not to say that we shouldn't be, with associations, shouldn't be taking steps to mitigate fire and other issues for the common area, for the property generally, for the association in general, and all in the community. But there is a difference between the association taking those steps, to protect and preserve the common area and the property and protect people generally, and also maybe get their insurance premiums down or be able to get insurance or whatever else that needs to happen. But communicating all of those steps and the way it's communicated to members, I think, is huge. It's a huge distinction in terms of what we're doing behind the scenes to make sure we can protect everyone and maybe even not spend $1 million on insurance every year. And then also let residents know that certain things are in place, and more importantly, they also need to be in charge of their own safety and security and have their own individual plans.
Great, thank you.
I think there was another question in the chat from Lori. Is the association responsible in any way when a garage gate is not functioning and left open, and as a result, several steps occur in the garage? Absolutely. That's a perfect example of when the association has failed to maintain the common area in a way that would be considered safe. So again, we can only do the things that we know about, right? So one is that if you ever receive an email from someone saying, I think the garage is not functioning, it needs to be a high priority for the manager, and that issue needs to be put on the board's radar immediately. Depending on the language of the management contract, frankly, you may have the ability to go ahead and to immediately call someone out because the expenditure is going to be less than whatever you're allowed to do as a manager, right? So understand always when it comes to safety and security things, what can you do on your own without the board's approval based off of those financial limitations that are contained within the management company contract. But if we have a safety issue of this nature where there is a report of something, I think it's an immediate jump to action. I think it's notifying not just the board members that this has been reported, but also you as the manager taking immediate action to find someone to come out as quickly as possible. You're failing to do that, not jumping on it right away may not necessarily result in anything bad. And you might have boards who are like, hey, let's just wait. I don't want to do an emergency call out. Let's just wait until they can come out, like not over the weekend, but on Monday. That's fine, but have them put that down in writing so that you as the manager are not carrying the responsibility if something should happen over the weekend, right? Because of that failed garage door issue. So this would be a perfect example of the association being advised about a problem that could have a significant impact on the overall safety and welfare of the community. So the association, in my opinion, should absolutely act as quickly as possible to address the issue. And if it's something that you as a manager can address, I think in an abundance of caution, you should go ahead and get the ball rolling on having that repair performed or having the inspection or whatever is necessary performed quickly, and let the board be the one to be like, no, we're willing to wait until this amount, or we want 3 more, we want 3 bids on this garage repair or something like that. Let them be the ones to accept the responsibility if something should go wrong. Because if you don't have that from them, then we know it always turns around and it's going to come back on management. Management was advised, how come the manager didn't do anything about this, blah, blah, blah. So, take those steps as far as you can as a manager would be my recommendation. And if there's going to be a pause or you're going to pump the brakes on it, let it be either because you don't have the authority to take the action, and put it on the board immediately put it on their radar. So you are waiting on them to give direction on how to act, or proceed as much as you can. And frankly, when it comes to safety issues, I think most board members will probably err on the side of caution anyways, and they probably will appreciate that you took the initiative to jump on a safety issue right away.
So what would be our responsibility in the case? Because we always immediately send out emails to the residents informing them that the gate is not working. Most times we can get it working within that day, but there have been a couple of instances where we had to wait for one part, we had to wait over a week. But so we've emailed the residents advising them, do not leave anything out, all the regular verbiage. But still, as a result, because we couldn't get the gate repaired, we were waiting for parts. There were a couple of thefts of catalytic converters. Now the homeowners are coming to us. They're saying, my insurance isn't covering all of it. I want the association to cover the rest. And
yeah, and I can see an insurance company saying that, especially because when it comes to vehicles, right, you usually have to confirm where your car is being stored. If it's in a garage, if it's outdoors, if it's in a secured spot or not. And insurance is based, insurance pricing is based off of that. I think that the best thing, I don't know that the association, frankly, in a situation like that, the insurance might not have to kick in or contribute something, to be totally honest. I think that's probably something that is best dealt with between the association's insurance company and the homeowner's insurance company. But what I would say is, I don't think it would be unreasonable to take the position of, as soon as we learned about it, we took action to help get it addressed. We had to wait. The delay was not a result of the association's inaction. It was a result of the part being on supply, right? Or the vendor, or whatever the reason is. We want to make sure it's clearly documented that we jumped on it immediately. We did everything that we could, and we notified the community about the potential risk associated with this that is outside of our control, right? I think that is really the best that we can do in a situation like this, because the fact is, something happened, right? Something happened. The property was less secure as a result of a component that the association maintained. So those are, in fact, the facts. But for the fact that garage was not functioning, those catalytic converters would not have been able to be stolen, more likely than not, right? No owner's going to walk through having removed the catalytic converter through the common area. Again, that's kind of it's a weird crime of opportunity, but it kind of is a crime of opportunity under these circumstances. So I don't really know what would be, how that would end up shaking out, to be totally honest. If we're talking about multiple claims from multiple owners, and these are large, expensive, demands, they're high value demands that are made to the association, it might be something that the association wants to talk to its insurance broker about and figure out if a claim could be made. But it might not even apply. It would really depend on the policy itself. And I think the best you would be able to do is emphasize that while it did result from the association's common area component not working, the delay that gave the opportunity for these crimes to take place was not the association's responsibility, and we had no control over it. Does that make sense, Lori?
yeah, totally.
Okay, great. Sure. I think there's another question too. Oh, come on.
Brent has his hand raised.
Oh, Brent. Brent, hi. Are you there?
Oh, you're muted.
There you go.
Oh, there we go. I want to follow up on Sarah's question about emergency preparedness. I believe I heard in past trainings that the association should not be creating the emergency preparedness plan. It should be an outside consultant, right?
Absolutely. Absolutely. If there's actually a plan that the association wants to put together, as opposed to just providing like websites or information, have a resource guide where people can go to contact, to contact for information or to get ideas. Absolutely. But if we're talking about it, the board actually wanting to come up with a plan, 100% that is not something that the board should be doing. That's not something your lawyer should be doing. That's something that the association should retain a consultant for. Yeah. Okay.
Also, the insurance companies love that, apparently.
Okay. Sarah's question: can an HOA board put up signs or leave up signs that state under surveillance if it knows or has chosen to no longer have active cameras? So they're just signs, but not reality. Okay, so Ellen's take is putting up signs which are incorrect poses risk. I would advise against it, but the board has to balance the risk. Likely should have legal opinion if board is considering it. Yeah, I think that this kind of falls under the discussion we have for question number 2, which is creating the expectation of safety and security. While I understand that signage can potentially be an effective deterrent, right? Truthfully, I don't think that it is worth the risk, because if in fact there is a crime and someone wants a copy of that surveillance footage, that's when the association is going to have to be like, yeah, it wasn't really a surveillance camera after all. They were just dummies. I think that if owners want to do that on their own property and accept that risk, that's totally fine. But if someone sees a camera and they live in a community, they're going to think that it's being surveilled, right? And if in fact something happens, the normal course of action is going to be, let's get a copy of that surveillance footage. And if that surveillance footage does not exist because it actually wasn't being surveilled, it is not a good look for the association. And I think that it creates actually more liability as opposed to less. So while I do think it could have some impact and it could be it's a visual deterrent for some, I think that the risk is far too great to go ahead and to put up signs like that when in fact they are just dishonest or untrue. Okay, we only have a couple minutes left. We'll do one more question. Penny, I have an association in Oakland that has continuous garage gate issues, and when we were unable to repair it during the weekend, the HOA hired a security guard to sit in the garage. Okay, not a question, comment. But yeah, I mean, I agree. If the association's able to do so, there are different ways to try to safeguard the area. If the association can afford to do this, I think that's a great alternative. And I think that, again, it's better than doing nothing. But I think first and foremost, it needs to be communicated to the membership, because I know that there are people who don't lock their cars, right? I mean, these things happen. Even in secure garages, people will, because they are secure garages, they think they're going to leave their cars, unlocked. And the association just needs to make sure that people understand that a component that existed on the common area before no longer exists. And maybe it's just for a temporary period of time. But if we're talking about the common area and there are expectations because the common area has been a certain way, maintained a certain way, or secured a certain way, or whatever you want to call it, if that changes, it's important for the membership to know about that so they can take additional precautions or maybe lock their car doors, right? But absolutely, if an association can afford some other form of safety while an issue is being addressed, I think that's great. I think that's definitely going above and beyond, but I think it's a great idea. So thank you for that option, Penny. So we have only 2 minutes left, and the next question was on cameras that are installed by the HOA and residents. This probably could be, I want to say actually, I did a legal hour with Collins like a couple of years ago that we really talked about. I feel like this is ringing a bell. I'm seeing some people shake their heads like, yes, maybe we talked about this. But, I think Cameras can be very tricky to address. The general thing I will mention, of course, is that if the association is installing the cameras, you have to make sure they're pointed only in the common area. It can't be pointed into anyone's home or any, private-ish areas or places where people have a reasonable expectation of privacy. That's the standard. And if the association is putting up surveillance cameras, make sure you work with legal counsel to come up with a policy that addresses all aspects of the surveillance cameras. How often they are running, whether they're being actively monitored by a person or not, whether it's just picking up images, under what circumstances and when those images from the surveillance cameras can actually be shared and with whom. So not just upon anyone's request, but I always say if it's law enforcement, that's the safest way. Give us a police report number. That's really making sure that the association is providing that information to an appropriate person and not just to somebody who wants to, find out what's going on in the common area. So this is kind of like a really big topic. I don't know if you want to throw something in the next couple seconds here about this, but really this would be and this is its own legal hour, to be honest.
It really could be. Really could be. The one note I wanted to throw in is that with automated license plate readers, so if there are cameras from Flock, I think there are maybe others that provide those, but if you've got boards who are considering installing Flock cameras, other automated license plate readers, I strongly recommend talking to counsel because there is a specific code in government code that has to be followed to a T in order to properly operate and utilize those cameras. And it is a much more complicated proposition than simply putting in our own cameras that just record footage randomly and don't send the footage in live time to a law enforcement agency. So if you're getting any of those, I strongly recommend getting an opinion on it because some boards are happy to fulfill all the requirements that the statute imposes, and some are going to decide that it is a huge deterrent.
Yeah. So it's just really rife for mistakes. And so we just want to be really, really careful when clients want to do that. And there's nothing wrong with them doing that in all honesty. I don't think there is. But you just have to proceed very, very carefully. So we're at the end of the legal hour. I tried to get through everything. Obviously, we didn't do a big enough discussion of this item. And then there was one other question, but I would be happy to build off of this for our next legal hour and any other questions. So Paul, thank you for the opportunity. It was really, really great to reconnect with all of you guys and to see everybody.
Thank you, Zer.
Yeah.
I wish we could do this in person, but how? I mean, everybody's all spread out. People are working hybrid, so I know your preference would have been to do this in person, but you still did great.
Other option is next time we can come in and whoever's in the office, we can do in person, but we could still have the Zoom or the Google Meet for those that are not there. So we'll get a little bit of in-person in there.
Okay. Yeah, we have that capability. I haven't used it in about 3 years. All right.
It's fine.
Thank you, Zer.
All right. See everybody later.
Thanks, sir. Thanks, Ellen.
All right. Good to see everybody. Take care. Reach out if you need us. Bye.